Good afternoon. What is a will? Do I really need one? Does it avoid probate court? What's the use? Well, today we're going to answer those questions and I'll give you 3 reasons why a will is actually beneficial for everyone. And when I say everyone, I mean people over 18 of a sound mind. Okay. And you can go back on previous videos that we've done and I explain exactly what that means. All right. So, first, let's get rid of the elephant in the room, if you will, the big caveat about wills. Wills do not avoid probate court. In our video last week, I mentioned that I was going to get to it, and I think I forgot that, so we're going to get to it today. Wills do not avoid probate court, okay? A will must be presented to the probate court and go through the probate court process to take effect. Now, this, kind of shakes some people because probate court, like all court proceedings, is a public process. So whatever is filed is open to the public because courts are public institutions, right? They're funded by our tax dollars, so therefore taxpayers, the public, have the right to access the information that's filed there. And so a lot of people want to avoid probate court because they want to avoid the publicity of it all. If you look at major celebrities, all the drama that goes back and forth with it, a lot of it could be avoided by, not having a will. So that's one caveat. It does not avoid probate court. If you have a will and a will only, then it will go to probate court. But guess what? If you don't have a will and you don't have any other estate planning document, you're still going to probate court. Okay? So we're going to get into the reasons why it's actually beneficial, regardless of if you have something else or not. We're going to get into those reasons, okay? But also, I just want to mention that the whole probate court process, this occurs after one's death, okay? And the person who makes the will is known as the testator. So after they pass away, they're the testator. Before death, a will is not effective. Unlike a trust, which is, like the other common estate planning tool. A trust goes into effect during the life of the person who created it, which is known as a settlor or the grantor. And you can go back on last week's video. We did a pretty good breakdown of what those terms mean as well. All right. But anyway, a trust goes into effect during the life of the person, the settlor or the grantor who created it, and it remains private, bypassing probate court. All right. So we got the big caveat out the way. Will does not avoid probate court, but don't fret. There are still major benefits to having a will. Okay. And today we're going to get into 3 reasons why, and we're going to kind of break down sub-reasons underneath them. So the first one that I want to point out is for minor children. A will is the only estate planning document where you can name a guardian for them. Okay, something you can only do in a will. This is important for single parents, for divorced parents with minors, for step parents, okay? Because these individuals may not have a spouse, right? Or in the case of step parents, it's a very unique situation, especially here in Michigan. You may want to check your own state if this applies. But here in Michigan, step parents do not naturally pass on anything to their stepchildren. Stepchildren do not do not naturally inherit from their step parents unless they're actually legally adopted. All right. So let's say we have a 12-year-old son and mother is the child's biological mother. She remarries and there's a stepfather. Well, let's say tragically mother passes away. Without a will, the guardianship of the child is left up for adoption, or is left up for interpretation, whoever wants to get involved. Because a step parent does not automatically have that right of parentage like a natural parent does, or like a biological parent does. Okay. And this is especially important if there is a situation of a single parent, a divorced parent, a step parent, where other parent was never really in their life. They may still be around and alive, but because they have this biological connection, who knows if they'll try to sneak in there or not. All right. And even if they don't, it's still important. There's been a case, I've seen it, not recently, this was some while ago, but minor child, okay? Mother was a single mother, died very tragically at 45 years old, left behind a minor child who was about 12 years old as well. There was no will. There was, no estate planning done. It was very sudden. Father was not involved at all. This was a choice by mother. So we have this child, this 12-year-old child, left without a parent. And what happened in that case was actually mother's sister, right? So aunt, but also child's godmother were battling for custody. Okay. There was no clear direction on who would get it, right? You have aunt, you have godmother. But without a will, there's nobody named specifically. So they both have kind of this, not this right, but they both have this claim to be, who's going to be the child's legal guardian. That happened with a single parent. All right. Divorced parents as well. For divorced parents, I will say though, and I'm not a family law attorney, but I know divorce decrees. You want to always check your divorce decrees when it comes to anything involving divorce, because a lot of that is going to be broken down in there. Okay. But either way, the will is the way to go to name a guardian for your minor child. That's the first major benefit of it, because obviously what's more important than the kids, right? The second major benefit of having a will is it actually will cover residue. It will cover things that were not included or missed in maybe other estate planning documents or other types of beneficiary documents. All right, so we'll go through a few here. A trust. So you can actually direct in your will, anything that wasn't named to be in your trust. Not a very popular option, right? But if anything was missed, there's a catch-all, there's a residue clause in the will to say that, anything that may have been missed in here, I wanted to go straight to the trust instead of having it go through these state guidelines, which we're going to get into next, all right? Bank accounts with no beneficiary. This is a big one. I see this happen so often. First of all, my first rule of thumb to anybody is always name somebody, okay? Not your minor children per se, but always name somebody on those beneficiary accounts, because that money can go directly to them, bypass probate court. A lot of times it's tax-free with life insurance policies, okay? Just do it, all right? Don't let it get snatched up. Don't let it get taken out of any other expenses. So bank accounts with no beneficiary. If you do happen to not have a beneficiary on your account, you can name in your will who will inherit such proceeds, rather than it going to the estate, which should go to like the general pot of whoever can have a claim to it. All right, whoever the state designates as heirs. We're going to go into that in the final one. Same with life insurance policies, other policies where you can name a beneficiary, but you don't have one. Name it in the will at least. So that way, that particular fund, those particular funds can be directed to the people that you want it to go to, and it won't get generally swallowed up in the whole of the estate. When that happens, all kinds of fees, administrative expenses, debts, from creditors, that can be taken out and deduce the amount of funds that can then be distributed. All right. So you want to make sure you have direct access to them. And there's no better way than just naming the beneficiaries in the policy and in the bank accounts. All right. And finally, for a will, the final benefit today is to set clear intentions, set clear boundaries. The wills are your will. It is your will be done. This is what it is, okay? You decide what happens, not the state. So this is what I'm talking about with the state beneficiaries, with these state heirs. Without a will or any other kind of estate planning tool in place, the state laws for inheritance take over. All right, every state has one. Here in Michigan, we have one, all right? And this may not be according to your wishes. Let's say, for instance, I just mentioned the stepchildren policy, that stepchildren do not naturally inherit from step parents unless they're legally adopted. So let's say we have a stepfather who passes away, had no children, but raised a stepchild as their own. And let's say, spouse has passed away as well. Who's going to get that money? If they never legally adopted a stepchild is not a legal heir. Okay. I also mentioned a lot of times, I saw this case happen in probate court recently. It was not my case, but while I was sitting in it, it was going on while I was sitting in court, where some kind of chemical company settled with a widow for the death of her husband. And they came to an agreement about how much it was going to be paid out as a significant sum of money. And they also came to an agreement about who was it going to go to. All right. 50% was going to go to the widow, and 50% was going to go to her daughter, who was not his biological daughter. She was a stepchild. The judge denied that agreement because stepchild could not naturally inherit from stepfather. Denied it. Even though all parties agreed to it, the judge would not accept it. Okay. But if there was a will there that specifically stated, this is my stepchild. This is my wish for my stepchild to inherit just as my natural child. That could have been avoided. Okay. And then stepchild could then inherit because it's according to the will, to their wish. All right. So the state laws for inheritance, they kind of follow in line with bloodline. So spouse is going to be first, if not spouse, children, not children, parents. It's all going to be immediate. So this is going to exclude people like aunts, uncles, depending on how much immediate family is still alive, okay? Aunts, uncles, cousins, grandchildren, grandparents, neighbors that you really care for, good friends, stepchildren. I mean, it's a very circular. It's a very tight circle too, which makes sense because it's like these are the people you would naturally care for, but you might have more people that you care for, right? You might have nephews and nieces that you raise as your own. Well, without a will, they're left out, right? If your own biological children are still there, your own spouse, etc. So you want to be able to distribute what you want to whom you want, no matter the relation, if it's somebody that you care about. Okay. Same thing with if you had a cause that you really support or a church. That's not in the state guidelines, okay, but it can be in your will. So if you want to continue your generosity, right, beyond the grave, you can put that in a will, you can put that in a trust, but it's not going to be if you die without nothing because the state does not cover that. So that's a big, big, big key, all right? And then also when you create a will, not only do you get to decide what happens, but the fact that you sat down to create a will, you did it with intention, with specificity, according to law, and especially when you execute it with the assistance of a legal professional. Okay, all the T's are crossed, all the I's are dotted. There are the 2 witnesses, might be notarized, 10 pages. I mean, the more you stack into it, the more you are declaring that this is my will. This is what I want done. And it's hard to challenge that. It's hard to challenge that this is exactly what you want it to do. Okay. And especially if you're updating it every so often, it can be challenged by, family who may not agree or neighbors, whomever may try to stake a claim to the estate. You know how that happens, right? Everybody comes out the woodwork. But if you make it as ironclad as possible by executing it according to law, having it look like it was done with specific intention, it's going to be harder to challenge, all right? Unless there's some kind of evidence of fraud or undue influence, like some kind of extra pressure. You see this happen a lot with older people who are more susceptible to that because they may have some kind of cognitive dysfunction like Alzheimer's, dementia, right? Which again, we talked about in the last video, maybe a few others, that you have to have a sound mind to be able to execute your will. But absent that, if you do it all according to the law and it looks airtight, it's going to be harder to challenge. Whereas, for some instruments, like honestly, if you just get down a piece of paper and you jot down what you want to happen and who you want it to go to, that's legal. It's valid. But who's gonna really? How credible is it? That's the thing. How credible is it? If you do it with specific intention, with a professional, you got all the T's crossed, the I's dotted, the credibility is oozing out of it. All right. And it's going to be harder to challenge. Your wishes are going to be held up 9 times out of 10. All right. So those are the 3 benefits of still having a will, aside from it going to probate court. All right. You can protect your minor children by naming a guardian for them. You can cover residue of things that may not have been caught or missed. You can set clear intentions and make it look like this is your will. Be done, and so shall it be. All right. So that's today's video. We'll see you next week. We come here every Thursday at 1:30 p.m. Eastern Standard Time. My name is Attorney Patterson. We will see you in August. All right. Take care.